Hey, welcome to Credit Makes Sense with Netiva, the Frugal CrediTnista, where we talk about money, credit, and everything in between. Super excited to be here with you guys today. We are talking about the updates made to the Fair Debt Collection Practices Act that take effect November 2021. So before, like last year, I believe, latter part of last year, I did a video on the updates that were made October of 2020. Then the final ruling for some more things that were lacking took place December 2020, and now they're going to take effect November 2021. So we've already talked about the October 2020 updates. I'll put the video down there for you guys to review. It was mainly about how they communicate with us. Now it's been updated from just telephone and writing to email, text, telephone, writing, social media messages like DMs and all of that good stuff, and how we are able to opt out of that. So again, I'll put that link for you guys below. The December 2020 ruling focused on three things: disclosures they have to provide for us when they send that initial communication to us that they own the debt or they now have the debt. Number two, what steps they have to take before they report our debt to the credit bureaus. That was a good one. And then number three, that they can no longer state that they're going to sue us over a debt that is past our statute of limitations. Before I move on, the statute of limitations is a law that varies per state that tells how long a creditor or collection agency can sue us to enforce payments of the debt. It has absolutely nothing to do with how long a debt stays on our credit report. It's all about using the legal system to force us to pay via judgment, or they can do wage garnishments, levy bank accounts, etc. So that's the statute of limitations. So let's break it down. The very first one that we talked about was what they are responsible or now have to disclose to us when they send us communication about the debt. That initial communication is called a dunning letter. In this letter, they have always had to state who they are, that they're a debt collector, their address, so none of that is going to change. Now, instead of showing how much we owe on this letter, they are also required to do like an itemized list of charges, debits, credits, fees, interest, and all of that good stuff. Interesting about this update is that they can provide this information over the phone, via email, or in the mail. This is a lot of information via the phone. So this was one of the updates. I was kind of like, And then I was also like, okay, I think that it should have just been via mail. Why do I say not email? Because not every consumer has a computer at home. Most of us are looking at updates on what? Our telephones. And when you take all of that information and condense it into a smaller screen, it is not always easy to understand and comprehend, right? That's my 2 cents. If they do call you, automatically tell them to mail it to you, okay? Give me that information in mail so you can have it. On the letter, they're also able to still, or they're also required to still do that 30-day notice to validate the debt. They can tell you about your consumer protection and how you can dispute the debt and all of that good stuff. So over the phone, that's a lot to take in. And also don't expect this communication to be easy to understand either. So we'll see. If you guys have a letter, you want me to take a look at it, I would love to take a look at the new ones. And in return, I can give you some advice on how to do what you need to do as well. If you're looking for free dispute letters, by the way, for validation letters sent to collection agencies, scroll on down to the freebie section in the description and you will see a link to my free community Credit Makes Sense. If you go to financial downloads, you will see free validation letters for you. Now, before reporting to the credit bureau, the collection agency has to now either call us or email or write us. So those 3 things. You would have thought this was always the law, but it wasn't. So like it used to be back in the day where they had to let that 30-day validation period go through before they report. But over the years, it was kind of like, okay, send a letter, report to the bureaus. And a lot of times my students and my clients were not finding out about collection, and probably some of you too, until you went to apply for something or you checked your credit yourself. And you feel like, where did this come from? Because you haven't received anything about this debt. It just seemed to like pop out of nowhere. And so now before they even go to the step of putting it on our credit reports, they have to, number 1, notify us via those 3 mediums: phone, email, mail, snail mail, And then they have to wait a certain amount of time to see if it actually gets delivered to us. Not sure how they're going to do that with email, unless they use some type of software to see if we opened it or not. That's pretty common, guys. Or mail, considering that the USPS have already said that mail is going to take longer, and this is kind of a permanent thing now, right? So they haven't specified how long the time period they're going to allow to see if the mail or email actually arrived to us or not. So I would hope they would do 30 days or so, but they haven't specified. But it's good that they at least put the law or the guideline in place. I'll have to see how it's going to be enforced, okay? Now, there was one more thing, actually a few more things that I wanted to go over with you guys, kind of like some pros and some cons, right? So one of the things that I had read is that debt collectors must observe the time frame that they can communicate with us. And that should be in the letter as well. But even if it's not, you should know that they can't contact you before 8 and after 9 o'clock unless we agree to it beforehand. And they also can't contact us at work if we told them that we're not allowed to get calls there. And so this has been beefed up a lot more, putting us more in control. And there should be opt-out language in like the DMs or the text messages or the emails that they send us if we no longer want communication there. Now, one of the things that I did not like, and I mentioned this before, is that all of this information can be told orally to us on the phone. The reason why I didn't like that is because a lot of times when debt collectors call us, we're kind of caught off guard from it. And then they're telling us all this information. It's like information overload. So I think it should still be in writing. Number 2, we can request that a debt collector stops using a particular method of communication. They must stop using it, and we can make this request orally. So it used to be that in order to enforce our rights, we would have to do it in writing. Of course, if we said it orally or verbally, some companies would accept that. A lot of them weren't. And so we would have to back it up with a letter or a fax in order to be like, don't call me, this is how I want you to contact me, et cetera, et cetera. Now we can do it over the phone orally. I still suggest that you be very detailed by making notes of when you told them this, what date, what time, who you spoke to, because just like we can orally say, if they give us information orally, I don't understand this, send it in writing, they can say, you never told me this. So now, one of the things that I talked about in the last video is the frequency of conversations, where they can only make 7 outreaches over the phone to about a day, right? So basically 1 call a day. Because it used to be we would get a call in the morning, in the night, in the afternoon, and it was like overwhelming. So they were like, 7 times in a 1-week period. But what I recently found out is that is 7 times per debt in a 1-week period. As many of you know, especially with medical collections and some of the most popular debts, such as Portfolio, LBNB, and Midland, they own multiple accounts, okay? So this what means if we have 3 collections with 1 collection account, what is 7 times 3? 21. They can make 21 phone calls to us about one of these debts, which is bananas. That's something I think they should have checked, because nobody wants 21 plus calls, and especially with medical debts. Because have you noticed with medical debts, it's usually like those little small 20-something, 100-something, 50-something, and they're each individual collection accounts. And so you can have someone with 7 accounts getting called 49 times. It's like, oh my goodness. So that's something I didn't like. Another thing that I didn't like, the Consumer Financial Protection Bureau said that collectors can provide required validation notices electronically in their initial communication. So this means that if we don't receive those notices, it's going to make it more difficult for those of us who have to read all that information in smaller condensed print over the phone, as I mentioned before. So that was that. Number 3, I didn't like that collectors can provide validation information orally, despite the large volume of information being received. So that means if I would like to dispute this debt, I would like to validate this debt. So we tell them this early, and we're like expecting them to say, okay, well, where can I mail this information to? They'd be like, let me tell you right now, get on the phone. It's like, it's just too much. So I thought that should have been fine-tuned a little bit more. And then it says required notices to consumers doesn't need to be in the language used in the collection contact. I actually just read that one today. I was a bit shocked. And what this basically means is that all of this information, that even that initial dunning letter that we talked about beginning, that initial notice that we have a debt, doesn't need to be in the language of the consumer, even though when they acquired the debt, they probably, I'm sure, they knew the language that the consumer spoke because all of the information is probably in the language that the consumer speaks. So the second largest spoken language in the US is Spanish. So at the very least, I expected it to be either English or Spanish, correct? But no, that's not a requirement. Everything can be in English, which means that if you are a Spanish-speaking American or only a Spanish-speaking American, this can cause more confusion. So that's something I think they still could have updated more. And then we have time-barred debts, or debts that are past the statute of limitations. One of the things that the new law, new guideline sets in place is that they can't use legal information for when attempting to collect. So they can't say we're going to sue you, or this could lead to legal action. They can't use any of that information with a time-barred debt. However, they can still pressure us to pay an account. And by pressure, I mean still call us, still write us, still email us, still DM us, still text us about the debt, even though it's past the statute of limitations. So I don't think that was, to me, if it's past statute of limitations, I think they should just stop collecting on it. That'll never happen, but that's my opinion, okay? The Frugal CrediTnista's opinion. Now, one of the things that I found out today as well, not only this, but this as well, and this was a workshop, and there was like a COVID-19 debts with people who have died from COVID-19. And so debt collection came up, right? And so it was stated that if loved ones are dealing with deaths of people who have passed, COVID-19 or not, that collectors don't have to provide validation notices or respond to disputes. So we are grieving our loved ones. We're trying to go, have you ever had to do that, kind of like go through the finances of a loved one that passed? And so you have these collections and you're like, well, I don't really know what's going on. Let me go ahead and just dispute this, try to get as much information as possible, request validation, get this type of information. So they will not have to provide validation notices, so those notices that I talked about, and they also don't have to respond to our disputes, which I thought was bananas. It was crazy. So there are some good things in here. There are some not so good things. I think this could have went so much further. One of the companies that I absolutely love, the National Consumer Law Center, I study a lot of their financial books, from bankruptcy to the Fair Debt Collection Practices Act, their Credit Reporting Act, and more. They just do a very good job at really advocating for consumers. And that's where I went to the workshop from, the little webinar that they had. And I know that they were pushing for so much more, and I'm just hoping they don't give up, because there's still, this was some nice little steps, but it wasn't I don't think consumers are as protected as they could have been with the updates that were made. So there you have it, the new updates that are rolling out in November 2021 to the Fair Debt Collection Practices Act. If you have any questions, comments, more info below, please let me know. And I will see you in the next Credit Makes Sense segment. Chat soon. Bye.